Let's take a look at training ethics. The law interacts with the provision of training and development in many different ways. Sometimes it's explicitly mentioned in legislation. Similar to other areas of human resource management practice, employers need to be concerned about the potential discriminatory effects when selecting who will participate in a specific training or development activity. Even if it's not explicitly mentioned in a piece of legislation, the legal environment impacts the decision of whether an organization should provide employee training. In most cases, the legal environment encourages organizations to provide their employees with training. The primary way the law promotes training is by lowering an organization's potential liability for actions taken by its employees. Jurisdiction refers to whether or not a specific law applies to your organization. Jurisdiction impacts discrimination in organizations depending on their geography and size. Depending on how many people your organization employs or where it's located, a particular law may or may not apply to you. In terms of organizational size, most anti-discrimination laws provide for a threshold number of employees. If your organization's workforce is under that threshold level, the law does not apply to you. While it's interesting to note the employee threshold for these laws, most organizations that employ HR professionals in some way meet the minimum. Legally, if a law does not apply to your organization, then by definition, you cannot violate it and you cannot be successfully sued for that type of discrimination. Even if you're safe from lawsuits, on an ethical level, there is a recognition that it's not appropriate to discriminate against another person because he or she belongs to a certain group. But if you can't be sued, how are such ethical standards enforced? If organizations or individuals violate such norms, they might find themselves ostracized. Consumer boycotts are one of the most visible responses to organizations that have a reputation for discriminatory behavior. Many organizations and products have been boycotted to varying degrees of success. In addition to consumer boycotts, which are visible, public, and can directly impact an organization's profitability, other individual and potentially less visible responses to discriminatory behavior can hurt organizational effectiveness. Discriminatory behavior can undermine the cohesiveness and effectiveness of work groups. Individuals who are the target of, or even a bystander to, discriminatory behavior will become demotivated and disengaged. Of course, this can lead to higher turnover, and if an organization develops a reputation for discriminatory behavior, then it will also result in a smaller applicant pool. Smaller applicant pools generally make it harder for organizations to find the qualified individuals that they need and can result in higher recruitment and selection costs. When people use the term equal employment opportunity or EEO, they're focusing on reducing discrimination. The main piece of legislation related to EEO is the Civil Rights Act. First signed into law in 1964 and amended in 1991, the Act protects employees from discrimination on the basis of their membership in a protected class. Title VII of the Civil Rights Act provides that people be treated equally in terms of compensation, conditions, or privileges of employment. Training and development activities fall within the list, and training is specifically mentioned in the Act. The potential to discriminate is present in both formal and informal training and development activities, either by who is selected to participate in a given training activity or by how someone is treated or evaluated within the program. As the name implies, adverse treatment occurs when employers treat their employees differently based on some protected class status, and it results in negative outcomes for the person making the charge of discrimination. Common reasons that people get sent to training include performance ratings. This can be either positive in the way that they may qualify for advanced training, or negative in that it might require some level of remedial training. Organizations should be aware that the method of delivery has the potential to create adverse impact. This is primarily a concern with training or development provided online. Once someone raises a concern about adverse treatment or adverse impact, an organization needs to be careful that it doesn't engage in retaliation by punishing someone who has made a claim of discrimination. The Americans with Disabilities Act, known as the ADA, passed in 1990 and amended in 2008, prevents discrimination against individuals who are disabled and also impacts the provision of training and development. One of the most important aspects of the ADA is that it provides for reasonable accommodation. Under the ADA, reasonable accommodation involves alteration of training to allow the individual with a disability to participate. Employers should also be careful that they do not limit training and development opportunities for older workers. Older workers might face discrimination based on false beliefs that they lack interest or represent a bad investment. While the main goal of equal employment opportunity legislation is to prevent discrimination from initially occurring, the law also provides for affirmative action, which is intended to promote the inclusion of systematically and/or historically underrepresented groups. Traditionally, affirmative action has been conceived as a way of addressing the underrepresentation of women and people of color, and organizational development can either be a target or a support for affirmative action plans. Organizations that have systemically or historically denied certain groups training and development opportunities need to include those activities in their affirmative action plans. The main reasons for providing training should be proactive and positive in nature. You should provide technical training to help your employees and your organization be more efficient, flexible, and innovative. And you should provide diversity training to promote a more respectful, progressive, and responsive culture. With that said, providing technical and diversity training serves defensive and protective functions as well. Both types of training can reduce an organization's liability by countering claims of either negligence or harassment. Safety and health represents one of the major categories of employee training. Workplace safety and health is governed by the Occupational Safety and Health Act, known as OSHA. In order to safeguard workers' safety and health, numerous standards have been developed. If employers do not provide training that is required by an OSHA standard, they can be found in violation of the Act. If a certain work activity or environment creates a foreseeable threat to employee safety or health, employers are required to take steps to protect their workers, including proper training. Employers can also be found liable for damages caused by their employees if they did not take the necessary steps to ensure that their employees were properly trained to do a specific task. While providing training is important to reduce the potential for injury or damages, nothing is absolute. This unfortunately includes the case of employee harassment. Employers that want to support and promote workplace diversity typically have taken steps to prevent harassment. These steps include providing training to employees so that they know how to avoid harassing their coworkers. In addition, these organizations have well-defined reporting procedures that employees are also trained on how to access and use. Although taking all of these steps makes it less likely that someone will be harassed, unfortunately, some people choose to be harassers regardless of how educated and despite the organizational culture in which they work. If harassment does occur, the organization can cite all of the training and related steps it's taken to prevent harassment and make a case for affirmative defense in order to avoid liability. While it is generally advantageous for organizations to provide their employees with training and development, organizations should not provide training and development to independent contractors. One reason is that because independent contractors are not employees in the legal sense. As such, independent contractors are not owed a variety of benefits, including unemployment insurance and workers' compensation. When an organization hires someone as an independent contractor, there is often a statement that clearly states the individual's status, and the person may even be required to sign a document stating that he or she is aware of his or her status. Despite the existence of such statements and documents, individuals can and do challenge their employment status in a court. Providing someone with training is a factor that would contribute to the court finding that the individual is an employee as opposed to an independent contractor. Such a determination would increase an employer's liability.